Hey there, I'm Mr. Terry and I'm a high school history teacher. Welcome back to another History Teacher Reacts video. All right, today we're headed back to Legal Eagle, and I think the mashup of he and I work out nice because you get the legal side of things and then you get the historical context. So I'm interested to see what he's got here. Now, this is a really popular video he did. It's called These Aren't Laws, Bad r/legal advice, because we all know Reddit is the greatest source of truth. All right, original video is linked down below. Thank you to all of the supporters over on Patreon and the YouTube channel members. You guys are getting extra perks like early access to videos and merch. And let's get started. All right, I think this could be very informative for me because there's probably a bunch of myths that I believe in. And if you believe in any of these too, let's just be honest. Let's admit to it. Let me know down below.
Thanks to CuriosityStream for keeping Legal Eagle in the air. Get 26% off CuriosityStream and Nebula using the link in the description. Everyone knows police can't lie to you. False.
Yep. That's right. The whole, like, have you ever heard the thing where it's like, if you don't know if somebody's a cop, like maybe they're undercover, and there's this thing that if you ask them if they're a cop, they have to tell you. Like, no, no, they're not going to at all. So historical precedent for that. Shoot, let's just go back to the founding fathers. It's like, who are you, the boss? You have to tell me if you're the boss.
If you ask a lawyer a legal question, the answer is usually, it depends. Because it usually depends. The law is a vast and complex thing, so...
You know what? We deal with that with history, too. People ask me these deep historical questions, like, what was the... like, why was this important, or was this good or bad, or something? And people do hate it, though, and I'm sure people hate it with lawyers, and you go, kind of depends on blank, 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 blank.
Won't surprise any of you that there are many misconceptions about what is and is not illegal. The law is complicated and it's easy to get confused if you have no legal experience. But the fun thing about law is that people tend to believe that there are certain hard and fast rules that are, unfortunately, definitely wrong. So let's dispel some myths and correct some misconceptions.
Beneficial for all of us.
And be honest, did you believe any of these things? Like, everybody knows it's illegal to marry your cousin. False. You can marry your cousin, provided it's your first cousin and you live in one of the 21 American states that allow it. Cousin marriage has always been popular around the world. Gross. But
hey, let's get some history, man. Man, can you imagine if that was banned in like Europe for all of history? Literally whole kingdoms and stuff tried to, and empires tried to keep themselves together by marrying within the families. Habsburgs, I think we're looking your way, right? They were super incestuous. It kept the empire together, but also gave them horrible defects, and they were crazy and all this stuff. So yeah, that's not going to be, and I'm just picking on Europe there because globally this has been a thing. This has been a thing more than it's not been a thing in history.
For hundreds of years, it was considered a relatively good bet for a long-lasting union. Think of all the family that you already share. But things started to change in America in the mid-
Are we looking at the Roosevelts for that one? Marrying your cousins? People, I think they used to believe too, and especially before maybe a lot of studies, that like a cousin was far enough away that like in your ancestry and with the health problems and the DNA problems of incestuous relationships, that a cousin was far away enough that it wasn't like a bad thing. Like it didn't mess with genetics or whatever. It was like far enough where it's like, hey, your sister, your brother. Okay, that's like a line, but the line was in front of cousin for unacceptability.
States decided that cousins marrying cousins was a bad idea. And interestingly enough, cousin marriages weren't ever outlawed in England, and they are still allowed in Canada, largely because the practice was associated with the aristocracy. In America, the situation was largely the opposite. Cousin marriage was viewed negatively in part because it was practiced by people who didn't have lots of money. But let's get down to brass tacks. First, cousin marriage.
That's what I was asking. Like, is it cheaper to marry your cousin? Is that what they're saying? That the more money you have, the further away the ancestry is going to be to your spouse. All right, Alabama, we know we were going to make
legal in Alabama, Alaska, California, Colorado, Connecticut, the District of Columbia, Florida, because of course, Georgia, Hawaii, Maryland,
Florida,
New Jersey, New Mexico.
You know, Florida
New York,
man is
North
doing
Carolina.
it.
In several other states, it's allowed with some restrictions. These states include Arizona, Illinois, Indiana, Utah, and Wisconsin, where first cousin marriage is allowed if the parties are above a certain age or one is unable to produce. Maine.
Wait, does that mean they're saying that underage marriage is completely legal in those blue states? I'm guessing if it's under 18, then you can get parental consent to literally marry your underage cousin. Is that the differentiation there? Someone let me know down below.
Also permits it if a couple obtains a physician's certificate of genetic counseling. Though note, if you do go through
What?
with it, Susan Collins
Doctor
may
says it's
express
okay.
her displeasure and furrow an eyebrow, but then allow you to do it anyway.
This is disgraceful.
But I guess this so-called myth is actually true in certain states. If you live in Arkansas,
Keep the
Delaware,
government out of the
Idaho, Iowa,
bedroom.
Kansas, Kentucky, hey, Kentucky, way to go. Louisiana, Michigan, Minnesota, Mississippi, Missouri, Montana, Nebraska, Nevada, New Hampshire, North Dakota, Ohio, Oklahoma, Oregon, Pennsylvania, South Dakota, Washington, West Virginia, or Wyoming, you'll have to look outside of the family reunion to find a spouse.
So what I'm interested in those ones is some of those ones like in the South or something, where the stereotype is that it happened more. Was it once legal and then it wasn't? That it became it became illegal because they voted it. But how many states had it never be law? Like it was never, or sorry, let me rephrase that. How many states had it so it was never legal?
Which brings us to the next myth, the
What we got?
reading of the will. Because everyone knows when someone dies, you
What do they
gather
mean?
in a big ornate room and then you wait silently until the executor
I've never heard
reads
of
your
this.
portion of the will and hopefully explaining that your estranged uncle left you millions of dollars, or if you were expecting millions of dollars, surprise, you get nothing, or you're left with just a haunted mansion.
I've never heard of this.
False. I'm willing to bet that no one who is watching this video has ever been summoned to a lawyer's office for the reading of a loved one's will. Nevertheless, many people still believe that when someone passes away, there will be a family gathering where a lawyer officially breaks the news
that's
about
common.
who will inherit money and assets. This is one of the most reliable plot lines for a daytime and nighttime soap opera.
I'm left with 40%. They are the major shareholders.
Soap
How
operas.
did Daddy do this to me?
The big event always takes place in the lawyer's office or old-timey
The whiny
library,
old
and it involves the whole crazy
lady.
family all in one room together. It's led by a well-dressed lawyer wearing Indochino, presumably, who gets to do the big reveal. Now, you can't blame screenwriters for wanting a reading of the will to be a real thing.
Yeah, I always remember that. That was like, yeah, like a reveal, and then there was like the lady there, you know, in the soap opera where it's like it was secret, or like the will was not allowed to get out.
It's a great way to create dramatic tension, and there's a lot riding on this dead person's estate.
I'm leaving you my keyboard. I'm going
Keyboard?
to keep it in my room at the Q Mansion. Please give it to Leo.
Will someone walk away rich?
Say keyboard?
Will someone be disinherited? Will someone unexpected show
Was
up?
it
Will there
epic?
be a fight? But here's the thing. There is no legal requirement that a last will and testament be read aloud to family members or anyone else for that matter. All beneficiaries named in a will are entitled to receive a copy so they can understand what they'll be receiving
what I
from the
figured.
estate and when those assets will be distributed. But there's no requirement that the executor usher everyone into a room where the contents of the will be revealed. In fact, lawyers would prefer not to do it this way since we aren't trained to break up fights like a bouncer at scores. Lawyers prefer to fight with our words, not our fists.
True.
And wound you with a pen rather than a sword.
All right, I wanted to say something historically, with some historical stuff about wills. You know, wills, as you can understand, can very much complicate family business, but they can also, in a way, change a lot when it comes to history. Let me give you an example. In the Middle Ages, there was this idea called primogeniture, and what happens is this: you had a lord, and they have a few children. So who inherits the land and the assets when the lord dies? Now, all of it would go to basically one individual. And so what that meant is that all the children, they don't get like the land and the power, and land is power, right, in the Middle Ages. Interesting fact, when the first crusades started, and some of the crusades, maybe after on, but especially in early crusades, some of those people that went and fought in the crusades were some of these nobles that were not in line to inherit the assets of their family line. And that's also why you married into other families as well. But so basically, if you wanted to have your own kingdom, your own land, you weren't going to get it in Europe. You're going to have to go and conquer it. And that was a motivating factor for a lot of nobles during the Crusades, is this idea that they would go conquer the Holy Land and all these lands, and then they could rule that land because they weren't going to get it back home. So it's, you know, the middle and young children are the ones that aren't going to get it.
So if there's no requirement for wills to be read out loud, where did this idea come from? Well, 100 years ago, estate attorneys did gather the family together to read the will because not everyone could actually read the will on their own. Nowadays, we sort of assume that the beneficiaries of a will are actually literate. But the main conflict in movies and TV shows involving wills is whether someone will be disinherited, and this is definitely a source of conflict in the real world. And since most states usually have a very strict time frame for contesting a will, it can be to everyone's advantage to start the clock by notifying.
What can you do to contest a will?
Earlier rather than later. This is actually what happened when President Trump's father died, because it's 2020 and everything involves Donald Trump these days. Fred Trump, Donald Trump's father, amended his will to disinherit
he is so
Mary Trump
scary
and Fred
looking.
Trump III, the descendants of Fred Trump Jr., who died when he was 46. Mary and Fred were cut out of a 20% share of their grandfather's estate that they might have received had their father lived. The other Fred Trump grandchildren are
So Donald got a lot of help.
Their parents' full shares in Fred.
I mean, I knew that he had inherited all his wealth, you know, and then used that to do businesses and stuff, but it screwed over his siblings.
Now, the Trump children, including Donald, told tax authorities that Dad's properties were worth around $41 million at the time of his death. The New York Times reported that the true value was closer to $1 billion, which
Where'd the rest
obviously is a
go?
lot of money to be disinherited from. Fred III and Mary filed a will contest 9 months later. Which brings us to the next legal misconception, because everyone knows if you go into a casino and you start counting cards, you can be arrested because counting cards is illegal. False. Counting cards while playing
No, so my understanding of this is you can get kicked out though, right? You can get kicked out if they feel they can refuse service. Isn't that right? Kind of like, yeah, you can refuse service to customers, you know, in some way. It's like the similar thing, but yeah, going to jail. I mean, it shouldn't be. You're smart. Like, what are you doing wrong?
Though widely considered to be illegal, is not. Really, you're just playing the game that the casino is offering at a much higher level than they were expecting. There is no local, state, or federal law that makes counting cards against the law. Generally, the way it works in blackjack is that it's more favorable for the player when there are more aces and cards that are valued at 10, the 10s, jacks, queens, and kings, remaining.
Is that movie
in the
21?
chute. So card counting is simply
was a good
using a
movie.
system to keep track of the ratio of low cards to high cards. And if you have a halfway decent memory, you can teach yourself to do this by tracking the changing imbalance of big and small cards in a diminishing deck. And since you're just using your brain, this is perfectly fine. There's even a court case making it legal, at least in New Jersey, because everything is legal in New Jersey. The New Jersey Supreme Court has ruled that players cannot be discriminated against based on their playing skills, even if they are caught counting cards. Counting cards does not violate the New Jersey Casino Control Act. However, counting cards becomes problematic if you're using a device to count cards or you have friends who are tipping you off. Though if you're playing in Nevada, the rules are a bit different. There's no Nevada law against counting cards, but the casinos also have free reign to remove people as they see fit. Casinos are private property, and they can remove just about anyone for any reason. So
That's where I'm wondering, like, you know, you have like these anti-discrimination laws and stuff that went up to do things like during segregation in the United States, where it's like you refuse service to a black man or something like that. So I wonder if those same challenges, though, that challenge those things could be used to challenge something like card counting, where it's okay, you may not be going to jail, but you are refusing service, the right to refuse service.
if you're caught counting cards in Vegas, even with your brain, you can expect the pit boss to pull you aside and prohibit you from playing blackjack. Which takes us to the next legal misconception, because everybody knows that you have to wait 24 hours to report a missing person, even if you know that your loved one is missing. You were there when the dark van pulled up beside your loved one.
I've heard of this,
the
but
sliding door opened.
don't think I ever
some
believed
henchmen
it.
who were wearing black shirts.
By the way, add historical context to that stuff. So gambling has been such a major part of certain economies. Okay, you get like Las Vegas. Okay, gambling, first off, is such a debatable topic, and people talk about this immoral activities, but then you have something like say the lottery. Idaho. Let me give you an example. Idaho, the state of Idaho. One of the things they use to justify like the morality, if you want to call it, of gambling is they use that money for education, for the lottery. The Idaho State Lottery, it goes towards education. So those that are like, it's like a sin or something like that, historically has been used to be defended against, because, you know, use it for something positive. Everybody wants more funding for schools. So like, hey, this is a way to do it without raising your taxes. So yeah, that's kind of some of the interesting story or interesting background about gambling in
Henchmen on
United
it, grabbed
States.
your loved one and threw him in the van. And
by the way, what do you think about that argument? If you're in a state that doesn't have like the lottery, maybe it's illegal or something. Do you think that's a justifiable way to put it in your society? Is if it at least some of it, I don't know if necessarily all of it, but at least some of it goes to things like funding education.
Move off, and then of course you go
Go back.
that said henchman on it, grabbed your loved one and threw him in the van and drove off. And then of course you go to the local chief of police, who of course you trust because he's been a longtime family friend, and you confide and say that you saw them abduct your loved one. And he says, look, I'm sorry, I believe you, but I can't do anything about it because you have to wait 24 hours before you can report a missing person. And it sounds reasonable. It
Sounds like a law that actually exists, but of course, your longtime family friend has been in on the conspiracy from the very beginning. So obviously then you have to take the law into your own hands because you waited 24 hours to report a missing person.
Yeah, because I mean, think about that. Let's say you're a parent and you have a child. Okay, I'm talking young, like elementary school age or something, and they're missing, and it's been a few hours, especially. They're going to listen to you. They're gonna be like, "No, sorry, your 9-year-old is gone. Sorry, it's gonna be 24 hours." That's that 24-hour time period is actually the worst time period to actually wait, because so many of the when you come to fatalities and murders and stuff like that, historically, a lot of stuff happens within that. Okay. And there's also, famous thing about the longer the time goes on, the harder it is to actually find that person.
But
because they get, if it's like a kidnapping victim, think how far you can travel in 24 hours. Right. Amber alerts and stuff, those go out quick. And when that was one of the big reasons why that went out, Amber alerts, have you heard of those? Is where you get those loud text messages on your phone straight from, the state or whatever. And there's a reason. Yeah, that's why that exists, because you want to catch it as early as possible. So they give you the car, of somebody and who they're last seen with, because the sooner the better.
is false.
Debunked.
A lot of people think that if a person is missing, you have to wait 24 hours to report it to the authorities. But in reality, there is no state or federal law requiring police departments to wait 24 hours before investigating a missing persons case. In fact, in 1990, the Crime Control Act became law, which mandated that all law enforcement agencies immediately report a missing child under the age of 18 to the National Crime Information Center at the Department of Justice. And in 2003, President George W. Bush signed the PROTECT Act, which included Suzanne's law, raising the age to 21. So anyone under that age could be reported to the national database immediately.
So my question would have been, if those kind of laws were in the books at some time, what was the point? Was it because people were burdening the police system with missing persons reports, and it was taking too many resources for them going out and looking for missing people rather than, doing all the other things that police do?
Suzanne Lyall was a 19-year-old college student who disappeared in 1998. And when Lyall's disappearance was reported to campus police, officers told her parents that brief absences were not uncommon for college students. So they shouldn't worry, since she would probably turn up. She was unfortunately never seen again. And as Suzanne,
aren't there welfare checks and stuff like that you can request?
For missing adults, police departments once had waiting periods before they would take a missing person's report. The common belief was that most people who seemed to be missing actually returned fairly quickly. Today, most law enforcement agencies have reversed course even for adults. This is partly because in the age of the cell phone, most people are reachable relatively quickly, and if they don't respond, something is likely to be wrong. But to sum it up,
true.
when an adult
that makes a lot of sense, actually, a lot more sense of why, especially today, you can't have things like a waiting period, because there's no reason you shouldn't be able to get into contact with somebody, right? Or at least not within 24 hours. And you got to go with the parent's judgment too, right? Or the spouse's judgment. I mean, they know what's a uncharacteristic long time for someone to not be in communication.
Goes missing, it should be immediately reported. And under Suzanne's law, federal, state, and local law enforcement must report all missing persons up to the age of 21 to the DOJ without delay, and the police are obligated to investigate right away. Which takes us to the next legal misconception, which is that if you are accused of a crime, everyone knows that you can't be convicted on circumstantial evidence alone.
Well, not unless a jury is gonna do that. So much evidence is circumstantial, especially the more of it you have. So
because everyone knows circumstantial evidence is weak and can't lead to a conviction. False. Criminal defendants often tell their lawyers, all the prosecutors have on me is circumstantial evidence, and you can't convict on circumstantial evidence alone. But the number one mistake people make about criminal law, and frankly civil law for that matter, is that circumstantial evidence is not enough to convict. But there's no law saying that. And in fact, the law says the absolute opposite. The standard of proof in criminal trials is beyond a reasonable doubt. And that means that the prosecution must prove that the defendant is guilty of a crime charged.
Which, as we know, is still a little bit of a gray area and still up open to interpretation. But if you tell that to a jury, maybe each jury member will have a little bit of a different idea, but I guess it's for them to decide what's beyond a reasonable doubt. I have some historical things to cite here,
to the
but
extent that
let me
no
let him
reasonable
finish here.
person could have a reasonable doubt that the defendant is guilty. And the prosecution can prove guilt beyond a reasonable doubt by building a case through direct evidence, circumstantial evidence, or a combination of both. Direct evidence directly shows the defendant's guilt, requiring no inference whatsoever. Direct evidence would be a video showing someone
DNA.
is killing the victim, or a witness testifying that they saw the person murdering that victim. Circumstantial evidence, on the other hand, is indirect evidence that may lead to the inference that the defendant committed a crime, even though there's no direct proof.
It'd be like an alibi they don't have an alibi, rather than a confirmable alibi, but they don't have one.
Key word here is inference, since circumstantial evidence allows jurors to infer facts that the prosecutors don't have direct evidence to prove. But circumstantial evidence can be extremely strong. Even DNA evidence, considered some of the strongest evidence out there, is circumstantial.
Oh, really?
For example, if a criminal defendant had traces of the victim's blood in their apartment,
Sure.
then you might make the inference that that person was in fact the killer. Though
Yeah, you're right. All that means is they were in the apartment. It doesn't mean they killed the person.
it's possible that that blood could have gotten there under other circumstances. So,
or maybe
that
you've
might
been
be
there, it just
extremely
wasn't
strong evidence, but there might be an explanation for it. That's
Or you didn't know,
circumstantial
didn't
evidence. Of course, not
plunge
all
the knife.
circumstantial evidence is created equal. Some is stronger and weaker than others, and this is where jury discretion comes in. It's up to the individual jurors to weigh the
Why we have
importance
multiple
of
jurors
each piece of evidence
and they
then decide
Why you also have multiple jurors and they need to be unanimous.
together whether the prosecution has proven its case. For example, there was no direct evidence that infamous Casey Anthony killed her daughter Kaylee.
She walked away.
The prosecution thought they had strong circumstantial evidence. Their theory was that Casey used chloroform to suffocate her child. However, the child's body was so badly decomposed that there was no definitive determination of the cause of death. The prosecution had evidence that someone in Anthony's household had done internet searches for information on chloroform, and traces of chloroform were found in the trunk of Anthony's car. And the prosecution hoped that the jury would draw an inference that the internet search and chloroform traces, along with the fact that Anthony didn't report her child was missing for a month, prove that she killed her child. And of course, a lot of people believe that as well.
Well, most everybody, it's so interesting. I remember that case now is just like, how could they let her go? Because there's, again, some things like, who doesn't call the police when your child has been gone for a month, first off? And allergies kicking in. Sorry, guys. Yeah, like it hasn't been in for more than been there for more than a month, and then you got chloroform everywhere. Whatever.
However, the jury did not think that that was enough to prove that Casey Anthony killed her daughter beyond a reasonable doubt. If the same case was tried to 10 different juries, it'd be interesting to know how many of them would have drawn the same conclusion. But
that's where I would be very interested. Because I think even if you did a poll, doing a poll of people that aren't actually jurors is going to be different than an actual jury. A jury there, you've got your instructions, better access to the evidence and those sort of things. But that was one of those things where, yeah, if you did a poll, then everybody, by far the majority would have said, yeah, she was guilty. But then again, it's also different when you're on a jury because you're putting that person's life in your hands. Because if she's guilty, they're going to execute her. Isn't Florida capital punishment state? Like, it's a little bit different when you have somebody's life in your hands than just some person voting in an internet poll.
That's not how our system works. You can be convicted or found not guilty based on circumstantial evidence alone. But that brings us to the next.
And let's remember, not guilty does not mean a ruling of innocence. There's no such thing as a ruling of innocence. Not guilty just means there isn't evidence enough to say that there's guilt. Didn't prove their innocence. That's where our legal system is. We can start talking about it now, where you have those ideas of innocent till proven guilty. So oldest writing code system that we have record of is Hammurabi, king of Babylon. Okay, good 3,500 years ago. And there, they actually, in that first law code, they actually said that evidence needs to be presented for a conviction, like evidence is required. And you have the legal right to like a defense and things like that. However, certain claims, and not everybody's claims were equal. There was definitely ways to abuse the system. They still had a class system where laws were also punished differently based on your social class. If you were, you know, an upper class individual and a lower class individual. Where you start seeing things look a lot more modern, though, is maybe something like Rome. In ancient Rome, you had things like be able to face your accuser, to also be able to do a defense, innocent till proven guilty, the idea of jury and things like that. Those were very much modern elements that, especially in like the United States, were tied from, and cultures going forward. But
Deception, which is that everybody knows that if you're doing something illegal and you think you might be interacting with an undercover cop, you should ask them if they are a police officer, because everyone knows police can't lie to you.
now what I want to know is how many stupid criminals thought this would work and it ends up not being that. Like, you know, you're going to a drug deal and you're buying from the cop. Are you a cop? No, I'm not a cop. And then you buy it, then boom, you're under arrest. Put the cuffs on. I want to know how many people actually did that. That would be funny. Is there some like funny law, like court videos that where they try to use that as a defense or evidence that that's actually happened before?
Our final misconception is that police cannot lie to you during an interrogation. Actually, they absolutely can use deception. There's actually a Supreme Court case on it. In Frazier versus Cupp, the Supreme Court affirmed the legality of deceptive interrogation tactics. Police in that case got a tip that Martin Frazier, a 20-year-old U.S. Marine, might be involved in the murder of Russell Anton Marlew. Frazier, along with his cousin, Jerry Lee Rawls,
Is this
were
one of
seen in a
those?
bar with the victim before the murder. During the interrogation, the police falsely informed Frazier that Rawls had already confessed and implicated him in the murder. Frazier denied any involvement in the crime and suggested speaking with an attorney, but police continued to question him. Police got Frazier to confess. This confession was used against him at trial, and he was convicted of murder. Rawls also pleaded guilty to the same offense. The Supreme Court rejected Frazier's appeal, stating that although police misrepresented Rawls' testimony, that did not make the confession inadmissible. And later case law has interpreted this as allowing deception during interrogations. This includes lying about evidence like fingerprints or DNA. However, there are some limits. Police, for example, can't misrepresent a person's basic legal rights. So if you don't know, now you know. Now, obviously, this is hashtag not legal advice, but hopefully you know a little bit more about what isn't the law.
All right. So yeah, those were interesting. How many of those were you kind of aware of? And yeah, so it's fun to be able to talk about some of the history around laws and maybe around the certain ones that were talked about there. So, all right, this was a lot of fun. Again, original video down below. Thanks again to channel members and patrons. And thank you all for watching. All right, we'll see you next time.